Great. Thank you very much, Diana. I am Teresa Michaud. I'm a partner in our Los Angeles office. And I was thinking today that since this is meant to be not a CCPA basics, that we would start out with a little test on have I violated a privacy law or not, and give you some fun facts that I know about each of my colleagues online. But unfortunately, none of them agreed to sign a consent or a waiver. So I guess I'll have to stick to some general comments, and you all can tell me in the chat whether I've gone too far. But all kidding aside, I'm really happy to be presenting today. I work with Lothar, Jonathan, and Ed all the time, and it's my pleasure to appear on the panel with them. Lothar, as many of you will likely know, has been practicing in the privacy space in California for more than 20 years. He does have a number of books, one of which we'll be giving away as our prize, but they're kind of known as the treatises covering all of the various California privacy laws. Jonathan is an associate that works with Lothar regularly in our Silicon Valley office, and Jonathan is licensed to practice law in both California and Ontario, Canada. So he's able to manage the obvious privacy complications between both Canada and the US. And he's very passionate about representing companies in Silicon Valley. Also with me is Ed Totino, who is a partner in Los Angeles, who is part of our securities litigation practice. And Ed has practiced in almost all of the courts in California, is a highly skilled trial attorney, and represents a number of financial institutions in California and elsewhere in class actions, including with respect to TCPA and California Invasion of Privacy Act claims. And for myself, I'm also a litigation partner. I split my time between our offices in Northern California and Southern California, and was one of the founding members of our Los Angeles office in 2018. And my practice focuses primarily on consumer class action defense. I'm the co-chair of the North American Class Action Practice, and I love working with companies in the e-commerce realm. So I think I stayed above board and didn't violate any particular privacy laws with that information, but I'm sure you can tell me in the chat, or Jonathan and Lothar can mention it in their presentation. But we're going to start out today, as I said, trying to stay away from just the basics. We will talk about California privacy laws as kind of the high watermark for the US, but obviously we know that privacy laws are being passed and or introduced in states across the country. So we'll talk a little bit about the risks there. We'll also talk about how to mitigate privacy risks more generally. And last but not least, I will talk about some trends in CCPA and other litigation, and other ways and mitigation efforts that you can make now to try to avoid risk to your own companies. So with that, I will turn it over to Jonathan.
Thank you so much, Teresa. Fun fact about me, I enjoy tennis, and I've been playing a lot more tennis actually since the pandemic, just because I live close to one. And it's a great way to de-stress. I also have a 2-year-old daughter, but I won't share too many details about her because she has not opted in, and I'm afraid I'll be selling personal information if I talk too much about her, which is something that's not really allowed under the CCPA. So I wanted to start with just the notion that California privacy laws may be viewed as a high water mark in the US. And traditionally, California has been a leader when it comes to the enactment of privacy laws. For example, in 2002, California enacted the first data breach notification statute. And since then, every state has enacted its own data breach notification statute. And then several years ago, California enacted the California Consumer Privacy Act, or CCPA, and that was seen as the first comprehensive consumer privacy law in the country. Potentially, there will be ripple effects. Now we're seeing other states pass or surface bills also aimed at regulating consumer privacy, such as Virginia, possibly Washington, maybe New York, we'll see. And so in this presentation, I'll be focusing mostly on the CCPA, as well as the California Privacy Rights Act, which was enacted late last year and which will establish a lot of amendments to the CCPA, the vast majority of which will become effective January 1st, 2023. Just because those are comprehensive laws that apply virtually to all businesses. But do note that California privacy laws also include dozens of activity-specific laws. A few examples are shown on this slide, and they're all handily summarized in Lothar Dietermann's California Privacy Law book, which you could be the lucky owner of if you enter the draw and win. And so what do I mean by high watermark? Well, I just think that California privacy laws are a good place to start when it comes to implementing your company's own privacy compliance program in the US. And it would in many cases, I think, set you up for compliance in other states. But there are a couple caveats. The first is that, of course, every state has its own privacy laws, some of which are different or more onerous than those of California. And second, it might not make sense really for your company to actually adhere to the strict California privacy standard for all of your activities across the US or even other parts of the world, given how onerous some California privacy laws can be, particularly with the slew of industry and activity-specific laws. Nonetheless, I do believe California is a good place to start. So let's dive into the CCPA and CPRA. Maybe I'll ask us to move to the next slide. And here we see on the left-hand side, some of the key components of the CCPA. And on the right-hand side, we have some of the key components of the CPRA. The CCPA column shows basically what is the state of the law today, whereas the CPRA column, rights and duties, will largely apply starting January 1st, 2023, although it will take time to prepare for that date. And so it's important, I think, for companies to start to prepare as soon as they're able to. On the left-hand side, the CCPA has essentially four pillars. The first pillar is the right to know and access. And this flows from foundational privacy principles that we see in the GDPR, in Canadian privacy laws, and other frameworks, Australia, for example. It basically means that companies have to provide privacy notices to individuals that explain to them what personal data is being collected, for what purposes it's being used, how it was processed over the past 12 months, and other important details. In addition, California residents under the CCPA have the right to request copies of the personal information that a covered business holds about them. That's part of the right to access. And just kind of because this is beyond the basics, one thing that I have found with respect to right to know and access requests is that, you know, it's important to really be responsive and at the same time to not try to be evasive, but also to be careful that you're not providing information about other individuals in those responses, that you're not providing trade secrets. Sometimes, in my experience, people who submit these types of access requests are people who are journalists who just want to try to understand how a company responds to these requests, or sometimes there are people who are actually interested in some of the vulnerabilities in a company's information security program, whether they're very quick to trust that somebody who purports to say that they are somebody is in fact that person. And so some caution is required, but certainly responsiveness is appreciated because otherwise complaints to the AG might flow from that. Another pillar of the CCPA is the right to deletion, and that entitles a California resident to request that a company delete personal information that it collected from them. And that's an important and subtle distinction from, for example, the GDPR. The GDPR allows any individual to request that a controller delete personal data about them, whereas the CCPA narrows that obligation to the personal information that the business collected from them. And so potentially that means collected directly from them. If it was collected from another source, possibly it's not covered by the scope of the right to deletion. Another pillar of the CCPA is the right to control sales of one's personal information. And this is a rather unique aspect of the CCPA. You won't quite find an analogous obligation under the GDPR. And sales, that's defined as the disclosure of personal information to another for monetary or other valuable consideration. And it means that California residents who are adults can request that a company that sells their personal information stop doing so. And it also it also requires businesses that sell personal information to obtain the opt-in consent to sell that information if that information is about a California resident who is a minor. That consent has to be from the parent or from the older minors themselves if they're between the ages of 13 to 15. And last week, I attended a session where Lisa Kim, who's a Deputy Attorney General, she explained a little bit about the enforcement practices of the Attorney General, which is the body that currently enforces the CCPA. And she said that, yes, the Attorney General does interpret the term sale to mean a disclosure beyond just disclosing in exchange for money. And even though there aren't any public enforcement actions from the AG yet, she did say that they have sent out dozens of notices of violation on a myriad of topics, but some of those notices of violation have specifically to do with this right to control sales. And what a investigator will do in that circumstance is it will actually ask the target of these notices of violation for copies of their data sharing arrangements and agreements with other entities, and they will audit them, review them, see whether there are any restrictions in place, because if there aren't, then potentially it could be a sale. And if there is no easy mechanism for California residents to opt out of those sales, then that could be an infraction of the law. And then the fourth pillar of the CCPA is this right to be free of discrimination, which essentially means that if a California resident exercises their affirmative rights under the CCPA, then you as the business cannot diminish the quality of your services or charge them extra as a result of their having done so, unless you do so in a way that complies with the CCPA. And in order to do that, to discriminate against people in accordance with the CCPA, you have to jump through a lot of hurdles. You have to do an economic analysis, you have to provide a notice of financial incentive, and there are other quite detailed requirements that apply. I call them the pillars of the CCPA because that's what I heard the Attorney General describe these as. There are other aspects of the CCPA that are important. For example, there is a duty under the law to train your workers and your frontline folks who receive requests from California residents to understand their obligations under the law. In addition, an important aspect of the CCPA is that it established statutory breaches for data breaches. Traditionally, before the CCPA, one of the major hurdles for plaintiffs who sought to recover in data breach claims was establishing standing or showing that they suffered some harm as a result of the data breach. And the statutory breach damages provisions of the CCPA essentially do away with that hurdle, because even if you don't show harm, you may still be entitled to statutory damages. So that's kind of the lay of the land now, but the CPRA will introduce a slew of new obligations and amendments. And so the first one is the right to correct inaccuracies. This means that somebody can write to your business and say, hey, you know, your personal data file about me is incorrect, out of date. Please update it. Here's my information. And then the CPRA contemplates that there will be regulations in place that explain how you can authenticate an individual's request to correct inaccuracies, how you can basically test what they're saying, and if what they're saying is authentic and accurate, you have to go through with it. In addition, there is a new right to control sharing, which is somewhat analogous to the right to control sales currently under the CCPA. And this really is a kind of double-barreled effort, I think, to govern the ad tech industry, because sharing in this case doesn't mean just any sharing among entities. It means specifically sharing for cross-context behavioral advertising purposes. It's not at all an intuitive meaning for the term sharing. It's unclear to me why they chose to use such a general term to describe something so specific. But what it means is that individuals will have the right to opt out of sharing. And there's also, just like there is under the CCPA currently, a requirement for businesses to obtain opt-in consent from minors in order to share their personal information for cross-context behavioral advertising purposes. And for me, I think one of the implications of this is that, well, first, it's going to have a big impact on the ad industry. And second, I think that if your business was previously doing a lot to ensure that it wasn't captured by the sales provisions of the CCPA, and you were doing things in the ad tech industry nonetheless, it may be time to consider just accepting that your ad tech reliance on ad tech services will be subject to these specific laws under the California law, and you'll have to implement some easy means by which California residents can opt out. So, you know, there are some additional points here. I'll just rattle them down. There's a new definition of sensitive personal information in the law. It differs from the definition under the GDPR, but it basically means somebody can tell you stop using their sensitive personal information for secondary purposes. And then there are also points in the law that contemplate that folks will be able to control whether and the extent to which you use automated decision-making tech to process the personal information. It's not listed here, but there's also going to be duties to perform risk assessments and to submit those assessments with the new agency that's going to be created to enforce this law. And there's also duties to perform cybersecurity audits on a regular basis. There's duties to use third-party data processing clauses and many other duties, including to observe general privacy principles such as the proportionality and purpose limitation principles. So moving on to the next slide then, you know, I think there's a list of top 10 action items here. I won't go through every single one, but I will highlight that I think that the first three action items here are very important. And the first is you just have to assess and understand, figure out what data processing activities your company engages in. And then it's important to plan a strategy, because just taking a reactionary approach to each of the obligations that I just listed is probably not an effective way to go about complying with the law. You should understand what exemptions might apply, what obligations might be too onerous for your company. And if some of those obligations are going to be too onerous, you might consider even moving some of those activities outside of California or just shutting them down for California. And then once you have that strategy, the rest is just implementation so that you align your activities and processing profile and footprint according to your strategy. All of the other action points essentially flow from those first three action items. And then the last action item here is stay up to date. That's super important because we're expecting a lot of regulations to come out explaining what all of the different rights and obligations I just described mean in practice, and it'll be important to stay up to date on those. That's it from me, and I'll turn it over now to Lothar to talk about privacy in other states.
Thank you so much, Jonathan. And we just heard about the pillars, and we heard the question whether California is a high watermark, which is an interesting symbol or metaphor. We're in an extreme drought. I think we're going to have a very hot and possibly fiery summer. And I would love to see more water. On the other hand, high water marks also stand for floods and for onslaughts, and high water mark could also be viewed that way. Certainly, California has called up this recent legislative activity. A number of states have been trying or are still trying to pass laws. Washington legislative period ended on Sunday, and they did not advance the Washington Privacy Act, which was a very interesting law because they couldn't agree on whether there should be a right of private action there between the House and the Senate. Florida still has this week also competing bills in the two chambers of the legislature with different rights of private actions on. But the ones that did make it are Virginia, which takes effect on January 1, 2023, with the CPR 8 changes that Jonathan just mentioned, and Nevada, which already took effect with earlier even than CCPA, but both of these laws were inspired by the original California legislation. One of the ACCA members had submitted a question, said, how do we deal and coordinate with all these different regimes? And I will address that question as I go through some of the points of what these statutes require. I start with Nevada. It's the easier law. It's refreshingly short and simple. Consumer actually what you think it means, namely somebody who buys things for private and household purposes. And it only applies to operators of online service and websites. So a much more focused law. Selling is defined like one would think for monetary considerations. And a company that sells has to publish a designated address where people can opt out if they don't like to have their information sold. No specific requirements of passing a do not sell my information link as in California. On probably the word count here in California is 10 times as high as what the Nevada law says in terms of all the complicated definitions. And I would say if you do put the California do not sell my info system in place, you could leverage that also for Nevada if you wanted to. I don't recommend offering automatically or promising to offer these opt-out rights to everyone, not because that wouldn't be a nice thing to do. I think a lot of people agree that it is appropriate to let people opt out of this, but because the specifics are so complicated, the definitions are so difficult, and a lot of information sharing is really important for economic activity, that I would recommend that companies address these things on a state-by-state basis, rather than to immediately promise for the whole world that they'll be entitled to all of these different requirements. They're typically not conflicting. You could do the strictest of all, but I don't know if companies will get that much benefit from it in the marketplace. And I think it could hold them back because marketing is important for competition. And therefore, I would recommend that you do this jurisdiction specific. A company that does not sell personal information for California purposes probably wouldn't get an enforcement action from the Attorney General and our neighbor to the east if it doesn't post a special address. But the way the statute is worded, you have to post a privacy notice that addresses Nevada residents, consumers. And again, I would do that jurisdiction specific. So I think a company should have one privacy notice that addresses people the way they want to, the way that comports to your values. And then you do supplemental notices with the very different terminology for California, business, service provider, Nevada, operator, Virginia, controller, processor, Europe, controller, process. But the terminology varies too much that I don't think the amount of time it would take you to draft one notice that covers everything and the creativity and the compromise that you would have to make. I think it's better to have a core privacy notice where you address people you want to, maybe under the law of your headquarters, which many of you attending here today is California, but not all of you. And then have separate supplemental notices to address these specific regimes. And there I would use exactly the terminology from the statute, maybe even the order of things as required by the regulations or by the statute already, and address all those points so you can check the box. When the statutes change, which they will do, you will be able to immediately find what you need to change in your notice. Whereas if you do one creative fits all purposes and some law changes, then you have to go back through the whole document and try to figure out where is that thing addressed and what kind of verbiage did we use and how do we translate the Nevada requirements to California speak or the Virginia one for Europe. The Virginia law is also inspired by CPRA already, but it uses quite different terminologies and there are different requirements. So I don't think you can assume if you do CPRA that you could just put in the definition at the top means consumer means California resident or actually consumer under Virginia Consumer Privacy Act, although that would get you probably 88% of the way there. I would recommend you do a separate notice for the reasons I discussed. Virginia defines consumer like somebody who is acting in a personal capacity, not employees, not B2B commercial, but somebody's buying something for personal household purposes. The law, like Nevada and most of the California law, is enforced by the Attorney General, not by a right of private action. This is what holding Florida and Washington back for now, that the attempt to enforce very prescriptive data processing regulation with private class action kind of mechanisms is something that many of the legislatures fear to unleash on industries other than the legal industry would greatly profit. So that is not the case in Virginia. You will have the same kind of data subject rights that Jonathan just described. So I think there, I would recommend when you describe what they are for Virginia in the special supplemental notice, you can tie back to the process that you developed for GDPR, for CCPA. So the plumbing can be the same, but the exception that you may take in particular situations when there's a request that is going to be very difficult for you to satisfy, say a 40-year employee wants all emails that have ever been written by him or about her, then you may want to look at the jurisdiction-specific exceptions that you can take why you don't respond to that. And they are different in every statute. But the plumbing in between at the back end, what you accept and how you respond to it, and at the front end, how you communicate it to it, those I would make jurisdiction-specific. In between the process, which team works on it, how do you route them, 45-day response times is the same in Virginia. That I would do uniformly. Otherwise, it'll be too much work. One of you in the audience asked whether this is on the business, California speak, or in Virginia, it would be the controller. The answer is yes, the service provider has to support. It should be addressed in the agreement. I think service providers can charge for this extra. It's extra work. And B2B, the market has to figure out what is appropriate, what level of support should be made available free of charge or for an extra compensation, because this does cost money. Ultimately, the consumers will pay for it, and the companies have to allocate this appropriately. We do have some opt-in requirements in the Virginia law that are very challenging. They're not all too different from CPRA. Jonathan was joking about it at the beginning. Children data can't be sold without getting a prior opt-in in place. But if you agree with your wife, Jonathan, on the custody and you do a family law analysis, probably you could make that decision for your daughter for now. And you could opt in if you wanted to. But it's going beyond a selling in the Virginia law, and any collection of sensitive data, including children data under 12, has to be specifically agreed to by the parents or guardians. That's a huge challenge, and I wouldn't recommend using modern technologies like autonomous driving cars and so on that need to recognize children on the street to drive in a state where you'd have to jump out and get permission before the camera captures that. I also don't think security cameras can be used anymore in states like that because it's just not feasible to take consent forms in place. Maybe the Attorney General will consider these things and come up with some more guidance on some extra exceptions. Maybe the legislators will cue this, but I think that is a big risk that companies need to take into account in terms of these opt-in requirements, which are extremely broad for sensitive information. Many of us have been thinking hard of what we can do for fighting discrimination, bias, racism in America. So a lot of racial information is being collected. That is defined to be sensitive information. And there's not an exception if you want to do something good with it. So you do need to comply with these onerous laws if you collect this information. And therefore, I think for Virginia, companies do need to go through a similar checklist that Jonathan had up there for CPRA. I think the bullet points are the right ones as well for Virginia and Nevada and any laws there to come, but it will not be exactly the same way to address them. And every company has to make its own decisions based on your focus, B2B, B2C, what exactly you implement which way. How to keep the sanity, and this goes back to the question that was asked in advance of this session today. I think companies should have a compliance dossier where you write down what you're doing positively to address these different points. Every new state law comes out, you take your top 10 out of it and write a few lines. This will be very important to keep track of what has already been dealt with and how, and also enable you to demonstrate how you comply. You know, under the European regime, 5.2 GDPR, every company has to demonstrate how it complies on request. And here in the United States, we have many safe harbors where companies can avoid punishment if they can show they had a decent program and that just an employee made a mistake. That's not expressly in the Virginia or in the Nevada law, but my guess would be that when you deal with an authority, they would take that very much into account. If you can show them you had a program, this is how you were addressing it, and maybe they don't fully agree with it, they require you to change it. Jonathan mentioned lots of letters have been sent, very few enforcement actions, but I think that would go a long way. So that is another recommendation on how to address these requirements. If we go to the next slides, we will see that there are great resources available. This one from the International Association of Privacy Professionals, which we're all members of, and if you're not yet, consider joining. There's a lot of crowdsourced and also from the IPP team editorial content, and they're tracking and researches all these different state laws and kind of give you an overview of what has to be taken into account. And I think companies need to keep an eye on this and use these resources in order to keep track on how to implement the different requirements. The final slide here brings me back to the question that Jonathan said, is it a high watermark? I think the California law on pretty much every point is still stricter, as strict as Virginia, Nevada, and other things. I wouldn't call them watered down, though. That's another name that I've heard. Because at the end of the day, I'm not sure that these super broad processing regulations are going to be more effective than this California law. The California law has too much complexity. And I think a more reasonably worded law that is focusing on real harms and real concerns will ultimately do more for privacy. All of us, of course, are looking towards Washington and see if something could come out that would preempt these state laws, but that would require an agreement on preemption and right of private action, and I think that is not in sight right now, is my sense. Enforcement is one of the key topics, and I'm really interested to hear now from Ed and from Teresa what's new on the enforcement side, particularly private action enforcement. Thank you.
Hi, everybody. I'm Ed Totino. I've been defending privacy class actions for the past 10 to 15 years, mostly in California, but also New York, Florida, Illinois, and other places. So I wanted to talk about two decisions that came out very important in the last, actually earlier this month on April 1st, that's going to impact privacy litigation and give you some tips as to how to address that. Well, first, there's a case, Facebook versus Do Good. It was a case under the Telephone Consumer Protection Act. That's basically an act that governs various communications with consumers, including auto dial calls, pre-recorded calls, do not call violations, and junk fax cases, or junk fax, advertising faxes. United States Supreme Court issued a decision on April 1st in that case that wiped out pretty much the auto dialer part of that law. I think that was about 80% of the statute. Now, the plaintiff's bar was filing 2018, 2019, about 4,000 TCPA class actions per year. They really like these class actions because they provide statutory damages, which is damages without having to show any harm, of $500 per violation. That could be tripled up to $1,500. With 80% of those cases now gone, that's going to leave a big area for the plaintiff's bar to look for a new area to focus on. What the Supreme Court did basically is define automatic telephone dialing system very narrowly, to say you have to use a random or sequential number generator, which no one uses anymore. Other courts like the Ninth Circuit had basically applied the statute to any automated technology, any computerized telephone dialing technology, which is what everybody uses these days. So by wiping out that 80% of the cases, the Supreme Court is going to basically tell the plaintiff's bar, you've got to find something else to focus on. Coincidentally, on the same day as Facebook versus Do-Good came out, Smith versus Lomi came out from the California Supreme Court. That was a case under the California Invasion of Privacy Act. That act generally governs the monitoring and recording of communications, either verbal or electronic. So what this California Supreme Court did in Smith is it, unlike the Supreme Court in the Facebook versus Do-Good case, it interpreted the statute very broadly and basically said 632.7 of the California Penal Code applies to any communication, regardless whether it's confidential, that involves a wireless telephone. So that statute, the California Invasion of Privacy Act, allows for $5,000 per violation statutory damages. So I think given that the TCPA was narrowed by the Supreme Court, and the same day the California Supreme Court broadened the California Invasion of Privacy Act, that's going to be an area of focus for the plaintiff's bar and bringing class actions. If we move on to the next slide. So one big defense under the California Invasion of Privacy Act is consent. If you have consent to record or monitor the communications, then you're not going to violate the statute. So what I would suggest is you all take a look at your consent provisions, look in your terms and conditions on your websites, look in your customer agreements if you have them. And what you want to do is put in multiple and redundant measures of consent to make sure that everybody who you're dealing with who may have their telephone or other communications recorded or monitored consents to that happening. Another area that the plaintiff's bar may focus on is the California anti-spam regulation. I've seen another number of class actions filed under that section in the last year or two. Federal canned spam law generally preempts the California law unless the spam has something the plaintiffs can claim is fraudulent or misleading. So what you get these days are cases claiming that for the email marketing in particular, the headers are misleading or there's other information in the email that is misleading. And the plaintiffs can seek $1,000 per violation, $1,000 per violation of statutory damages for that. Another area that may be a focus of the plaintiff's bar is session replay litigation. That's basically where consumers interacting with your website, and you have a system in place that records their interactions, mouse movements, clicks, what they enter in the screen even before they send it. And in California and Florida so far, the plaintiffs have been trying to expand the California Invasion of Privacy Act and other wiretapping laws like Florida's and the federal one into these types of situations where a company puts in a software program that keeps track of what's going on its website. Those cases are relatively new. They've been filed in the last couple of months, and there hasn't been much decisions in the area. But they're going to be enticed by the $5,000 per violation statutory damage in California. I think it's $1,000 in Florida, and there's going to be more focus on those laws. Let's move on to the next slide. That's just the various provisions of the California Invasion of Privacy Act. As you can see, there's multiple provisions there that the plaintiffs can try and take advantage of to get the $5,000 per violation. And you know, as you might expect, that adds up very quickly for any company with a substantial customer base. Just moving on. So as I mentioned before, with the California Invasion of Privacy Act, consent is a big defense. That consent can also apply to session replay litigation. So in addition to putting consent provisions in your customer agreements, terms and conditions on the website, if you are going to use this software that monitors what's going on with your website with consumers, I would suggest you look at some other ways of putting consent. For instance, there could be a notification at the bottom of the page, each page saying your interactions with this website may be recorded or are being recorded or are being monitored. So once you put if you have multiple layers of consent, it gives you a real defense to the class action litigation in this area. Moving on to the next slide. So other than consent, there's a few other things you can do to protect yourself in these kind of cases. One is, and this may go against the business need for standardized processes and also compliance need that Lothar mentioned earlier, but to the extent you can put variability into your agreements and interactions with consumers, it makes it much harder to bring a class action, because in a class action, the consumers want to say, you treated everybody the same way and what you did was wrong, and therefore we can bring a class and obtain enormous amounts of damages from you. To the extent you can go back and say, well, no, this decision was made on a discretionary basis, or these consumers were treated differently than other consumers, it makes it more difficult for the plaintiffs to get a class together. Other provisions that could help you in mitigating litigation risks are, if you look at your vendor contracts or service provider contracts, make sure your indemnity provisions are tight enough and that they cover all the situations you can think of, like session replay litigation, other interaction with consumers. The other thing to look at there is see if there's any limitations of liability that may prevent you from getting full indemnity. And also, to the extent you can put limitations of liability in your agreements with your end users, with your customers, take a look at doing that. Also, I think Lothar touched on this a little earlier, the choice of law or venue clauses. We've had some success if a company is based somewhere outside California and they have a choice of law and venue clause in their agreement with the consumer, of transferring it to a more favorable jurisdiction, because California courts are not the best for companies these days. So you can consider that. I believe this judicial reference clause is another way. Maybe about 5 or 10 years ago, the California Supreme Court held that you can't have a pretrial jury waiver in a contract. So the only way to really get out of a jury trial in California when you're being sued is either an agreement after the fact, which is pretty much not going to happen, or you can do a judicial reference clause, which basically sends it to a private person, but within the court system. The other way of doing that is to use a arbitration clause with class action waivers, which I believe Teresa is going to talk about now.
Great, thanks, Ed. Yeah, so with the few minutes that we have left, and I want to make sure I leave enough time for some of the questions that have come through the chat, I do want to highlight just a few trends regarding litigation, especially with respect to the CCPA and things to watch out for. So before I get into kind of the class action waiver and arbitration clauses, I do want to just give you a quick overview of CCPA litigation. So obviously in the last year, we've seen a number of cases filed, and we've written a few articles on this that are available through our website or a couple of our privacy blogs. But in general, obviously the bulk of the litigation in the past year has been with respect to data privacy breaches or incidents. 1/3 of those are related to the alleged data breach of the California Employment Development Department's information, so EDD cards through Bank of America and other tangentially related actions. But there are three other theories that plaintiffs' attorneys have been advancing in order to bring litigation based on the CCPA. And those are under the UCL, under negligence per se theories, and also breach of contract theories. Now, the CCPA, as many of you know, already says that the private right of action should be limited to the data breach scenario. But there are some arguments that the statute language doesn't go far enough to prevent it from being considered a predicate act for a UCL claim in California. The good news is that we do have one decision as of this February from a magistrate judge in the Northern District saying that without claims of a data breach, the CCPA cannot be used as a predicate act for the UCL. Now we have to see whether other district court judges in California and ultimately the Ninth Circuit will agree with that decision, but at least now we do have at least one precedent kind of ruling out the UCL in order to enforce the CCPA, which is good news for defendants. The other two theories will take a little bit longer to work themselves through the courts. So negligence per se essentially argues that if you have violated the compliance provisions of the CCPA, regardless of whether there's been a breach, that itself constitutes negligence because you should be meeting that high water mark of the California statute in your compliance acts. And of course, breach of contract is a pretty straightforward cause of action, but if you are making representation to consumers that you are in compliance, for example, that you will not sell their information, but then there is a potential allegation that you've not complied with your own statements to consumers, the likelihood is that will give rise to breach of contract action. So that kind of gives you an overview of what's happening on the litigation front, but we will see how those theories all pan out in the courts, I think, throughout the rest of this year and further. I do want to bring your attention to some trends that we are seeing in CCPA litigation. And that is the use of the access rights that Jonathan mentioned as a way to get pre-suit discovery or as a way to get very early discovery in litigation or arbitration. And so I think one thing to keep in mind if you are working with your litigators to try to strategize how you're going to respond to those requests, focus also on how you're going to verify requests from consumers. Ideally, you want to be sure that you are providing information only when you have to and only the information requested. And you should build in some obstacles to just providing private information of consumers to anyone who asks for it, claiming that they may be representing consumers as their counsel without actually giving you the consent from the consumer, him or herself. Also, plaintiffs' attorneys are using this as a way to kind of check what information the company collects and how in order to better frame their discovery requests. So keep that in mind also in how you are responding and what other information you might be providing that says more about the company than you would want plaintiffs' litigators to have before you enter formal discovery. So then another trend that we're seeing right now are mass individual arbitrations. And this goes to one of the points that Ed raised, which is arbitration clauses and class action waivers. We've advised a number of companies that this is one way to help curtail a flood of class actions because obviously the California courts, although they try to fight consumer class actions at every turn, according to Supreme Court jurisprudence, they are required to enforce arbitration clauses that can include class action waivers if they're subject to the Federal Arbitration Act. So we still recommend that that is one way that you could mitigate against the class action risk. On the other hand, what we are now seeing are entrepreneurial plaintiffs' attorneys who are gathering hundreds and thousands of individual consumers and threatening to file mass individual arbitration claims. As you've probably heard for a couple of Silicon Valley companies, this really started in the employment context where it was easy for plaintiffs' attorneys to get contact information of similarly situated class members because their client has the contact information for other employees in the company. In some instances, plaintiffs' attorneys were able to gather thousands of employees and then force the company at the get-go to pay the filing fees for the AAA or JAMS tribunals, which amounted to millions of dollars before the cases even took off. So obviously that gives the plaintiffs' attorneys a lot of leverage in these cases if the company could be facing $10 million in filing fees just to participate in arbitration without moving the needle closer to a resolution. And the courts have enforced arbitration clauses in that context. So one thing that we're working with a number of clients on, and also with specific tribunals, is factoring that into how you frame your arbitration clause and class action waiver to try to allow for potential consolidation or cooperation and coordination in what we consider pre-hearing, like pre-trial discovery and litigation. So that's a trend to watch for. And lastly, not to forget, I couldn't be a litigator on this presentation without pointing out that you certainly need to watch for the overlap between litigation holds and deletion requests, and factor that into how you respond to access rights and deletion rights when they're coming from consumers. Make sure your litigation team and your privacy team are aligned on that point so you don't accidentally violate one of the obligations. With that, I'd like to turn it over to some questions that we've had in the chat. I believe one of the first ones, Lothar, I'll actually turn it to you, that came directly out of the chat. And I'm not sure if you've answered it already or not, but one of them is, do the Virginia and Nevada laws exclude nonprofits like the CCPA does?
They do. The Virginia law has a specific carve out. It's a little hard to find because it defines the covered person. Nonprofit.
And I'm sorry, Lothar, you cut out for just a second. So could you just repeat that last
only
sentence?
apply for profit. Only apply for profit, Virginia and Nevada. All our private sector laws don't apply to government. The California law is a little bit difficult. Right. It may apply, the California law may apply for some companies that are for stock and for the financial benefit of their members. There are some co-ops that are actually covered by the California law, even though they might qualify as nonprofits.
The next question I'll turn to Jonathan. Jonathan, can you give us any insight about whether Congress is going to give us a national consumer privacy law, or is this really a lost cause?
I wouldn't put any money on, anticipating a national consumer privacy law being enacted anytime soon. I just think that there's a lot of other fish to fry right now, and there's a lot of gridlock in Congress. So I think we'll just have to deal with state by state laws for the time being.
Ed, the next one really goes to something you covered, which is, would session replay cover tools like Google Analytics?
You'd have to look at the exact way the system works, but if it's capturing what could be considered the communication between the user and and either the company putting it on there or a third party, it could potentially be covered by the session replay. As I had mentioned, consent is a big defense in this area. So to the extent you can put some kind of notification that their interactions are being recorded, monitored, or analyzed, you have a good argument of implied consent at least, because the argument is if they continue using it after being notified of that, they've consented.
Our next question, I think Lothar or Jonathan, you may have answered this partly in the chat previously during your presentations, but the question is, if we are not a covered business under CCPA, however, vendors have asked for contract provisions saying they are a service provider under the CCPA. Does accepting that provision put us at risk of having to abide by the CCPA or being deemed a covered business?
I'm happy to take it unless Johnson wants to. I would say it's fine to accept these clauses because you would not contractually accept it vis-a-vis anybody except for your customer, but you should clarify with your customer what exactly they expect you to do. If they just expect you to do what a service provider has to do under CCPA, I think you can probably promise that in most cases and it wouldn't be a problem. And the CCPA regulations say that even if the business is not under the California law, then a service provider could still benefit from certain exceptions and vice versa. So I think it would be fine to accept that.
Okay. Our last question, Jonathan, maybe you want to take this one, which talks about what should we be doing to prep for employees' data falling within the scope of the CCPA or CPRA?
Sure. So first, I'd like to start by saying that there is a notice at collection obligation, which is already in force with respect to employees. Arguably, this is it's a little complicated, but the argument is that this obligation is in place. And what that means is companies have to provide a so-called notice at collection to their employees that already contains the information required under the CPRA as well. So also information about whether you're sharing their personal information for cross-context behavioral advertising purposes. This despite the fact that the employee and other personnel moratorium extends until January 2023. So companies would be well advised to start implementing those notices at collection for their personnel if they haven't already. And then because of the moratorium that I just described, CCPA currently generally doesn't apply to the processing of personal information of employees, contractors, and other types of personnel. But in preparation for January 1st, 2023, certainly cleaning up a data retention policy is an excellent thing to have done, but also just ensuring that your notices are all up to date, that your privacy policy reflects your processing of personal information, that you have protocols in place to respond to data deletion requests, data access requests, data updating requests, and so on and so forth, and just basically treating your employees like any other consumer or California resident under the CCPA.
Great. So I think we've now gone over by a couple of minutes. We do have some other resources available to anyone who wants more information on the privacy laws that we've covered today. And of course, please follow us on a few of our blogs, Connect on Tech and Be Inform, or I'll sign up for some of our client alerts from our privacy team, and you'll get this information as we publish it. But with that, I will turn it back over to Diana Francis, and thank you for everyone who dialed in today.